that women deserve better. Thank you.
Hi, I'm Chris Kobach. I'm the Attorney General of the state of Kansas. It's my honor to be here representing not only my own state of Kansas, but also the other states that have intervened in this lawsuit as co-plaintiffs in the court below. The actions of the FDA here are not only injurious to the unborn with dangerous consequences to the mothers, but also they injure states' rights with dangerous consequences to our Constitution. In the wake of the Dobbs decision, the regulation of abortion was returned to the states where it originally rested under our Constitution, with the exception of the erroneous departure during the Roe era. But by unlawfully creating a system where abortion pills can be mailed to individuals in any one of the 50 states without a physician present, without an in-person doctor's appointment, and without any medical examinations afterward, regardless of what the state laws require, and regardless of the fact that that state may not allow abortion by mail, the FDA has overridden state laws with the stroke of a bureaucrat's pen. After the FDA's decision, and in spite of the Dobbs ruling, private organizations started mailing abortion drugs into all 50 states in large quantities. In less than 1 month in the summer of 2023, 7 U.S.-based providers mailed 3,500 doses of mifepristone into states that had banned the use of chemical abortions or had prohibited the distribution of those chemicals by mail. So let me make that clear. 3,500 cases that were violating state laws in less than 1 month. The FDA has radically interfered with state sovereign authority to set abortion policy. Indeed, the Dobbs court described abortion as one of the most profound issues of public policy. The court very clearly left it to the states to determine whether abortion would be permitted and under what circumstances. Each state, regardless of where they stand on this issue, each state has a sovereign interest in deciding that issue for itself and in compliance with the wishes of the people of that state. Abortion is one of those public policy areas that the court has very clearly said resides in the states. Our state legislatures determined that abortion drugs must be dispensed in person, not through mail. They had good reason for doing so. Chemical abortions not only result in far higher percentage of complications resulting in trips to the emergency room, but they also open the door to coerced abortions. Without a physician present, it is far easier for a boyfriend to coerce a woman to take the abortion pill or to slip it into her drink. But regardless, each state is free to make these decisions and assess the risks for itself. That is the essence of the federalist model that is woven into our Constitution. The Founding Fathers never imagined that the federal government would interfere with the state's rights to regulate abortion, much less that an unelected agency of the federal government would basically sweep aside all of those in the state legislatures. That is why we states have intervened in this lawsuit. We stand with the physician plaintiffs here, but we also stand in defense of the constitutional authority of each state to decide these policy matters for itself. Thank you.
All right, we'll now take a couple of questions for Erin.
So there's nothing in the lower court's ruling that would impede access. I think we should all agree that if women decide to use abortion drugs, they should be safe. The FDA's removal of in-person visits removes the best opportunity for a doctor to diagnose ectopic pregnancies or life-threatening conditions. It's simply unsafe to mail drugs to dorm rooms without women having seen a doctor.
Any other questions? All right.
So the case today was about women's health. Do you think future cases could push the argument further so that the original briefing, all the issues that you raised, including the 2000 approval, which was already illegal, do you think that could be challenged in court following a favorable approval in this case?
So the Fifth Circuit found that determination untimely. So what the court is looking at today is, as you said, protections for women's health. So whether these drugs can be mailed across the country without ever having seen a doctor, whether the gestational age can rise even though surgical intervention rates rise along with those gestational ages.
All right. Thank you guys so much.
Why they have standing to bring this suit. The fact is they don't. Second, Congress entrusted the FDA with the sole authority to approve new drugs and subsequent changes. The federal judiciary has respected that authority for decades, applying an appropriately narrow standard of review to FDA's drug approval decisions. In approving mifepristone nearly a quarter of a century ago, and in its subsequent changes to how the use is prescribed and used, the FDA acted on an extensive body of evidence and well within its authority and in accordance with the law. Second-guessing the scientific, data-driven judgments of an independent agency is an extreme position that could inject uncertainty across American life. Under the respondents' theory, the medicines Americans rely on to manage and cure any number of conditions and diseases could be in jeopardy years after FDA's approval. And the ability of the American pharmaceutical industry to develop and get approval for new drugs would be severely harmed, slamming the door on promising research into medicines for everything from Alzheimer's to cancer. Fortunately, there is no basis in law or precedent to find for the respondents, and we have urged the court today to overturn the Fifth Circuit's decision. We thank the court for its time and attention in this matter, and we look forward to its resolution of the case. Thank you.
This is the